So the Supreme Court had a ruling today. Supreme Court of the United States. Kristi Noem, Secretary. I guess let me put myself up here instead of down there so you can see it better and not get missed by a bunch of this stuff. Maybe we put this down a smidge to see more text. Anyway, so the application for stay presented to Kagan and her referred to the court as granted on July 11th, 2025. Order entered by the District Court for Central District, California is stayed pending the disposition of appeal in the Ninth Circuit Court of Appeals and a disposition of a petition for a writ of certiorari. If such a writ is timely sought, should it be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate among sending down the judgment of the court. Justice Kavanaugh concurring in the grant of the application for a stay. I vote to grant the government's application for an interim stay pending appeal of the district court's injunction. The Immigration and Nationality Act authorizes immigration officers to interrogate any alien or person believed to be an alien as is his right to be or remain in the United States. Believed to be, but are they really using believed to be as justification? Immigration officers may, quote, briefly detain an individual for questioning if they have reasonable suspicion based on specific articulable facts that the person being questioned is an alien illegally in the United States. But is that what was going on? No. Reasonable suspicion inquiry turns on the totality of the particular circumstances. What totality is that, mind you? The government estimates that at least 15 million people are in the United States illegally. Many millions illegally entered just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. About 10% of the people in the LA region are illegally in the United States. Based on what numbers? The administration's numbers? If you believe the administration numbers, I have a bridge in Brooklyn I'd like to sell you. Meaning about 2 million illegal immigrants out of a population of 20 million. Not surprisingly, given those extraordinary numbers, U.S. immigration officers have prioritized immigration enforcement in the Los Angeles area. Hack. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants, and who do not, and again, I'm using the words of the justice and not the words I would use, and who do not speak much, if any, English. None of those are things that, should give anybody probable cause to stop and detain somebody under reasonable suspicion for being somebody who's here in violation of our border policies. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. Bullshit. We've covered many stories on this show already where immigration officials have not worried about whether or not the person is here legally or not, if the person is a citizen or not, or whatever. 18 people deported out of Norfolk, Virginia. Actually, it's now up to 28 cruise ship employees who have been terminated, who have been seized and deported and banned from re-entry into the United States because they wanted to get their quota numbers up, not because they were here illegally or in violation of our laws. Citizens have been deported. Children citizens with brain damage, with brain cancer, getting treatment for other injuries that to deal with. People here legally with given permission by the U.S. government to be here to get medical treatment are being deported despite the fact that they're here legally. A woman from Iran who lives in Lakeview in New Orleans, who has been living here for years, has been given the permission to stay here for years and was seized and, detained because how dare she, exist as a human being in this country and not as a citizen. So no, I do not believe you, Justice Kavanaugh, or anybody else who sided with Justice Kavanaugh on this ruling, and we all know who they are, simply because of the fact that this administration is not doing what you're saying they're doing. Immigration stops based on reasonable suspicion of illegal presence have been an important component on U.S. immigration enforcement for decades across several presidential administrations. Except this administration is not having reasonable suspicion to stop and detain people. This administration is going for immigration raids, and when they're going after one person, they'll be like, oh, we'll just grab him too because he's in the proximity. Let's not give a crap about whether or not these people are actually violating our laws or not. In this case, however, District Court enjoined U.S. immigration officers from making investigative stops in L.A. while the stops are based on the following factors or a combination of factors: presence at particular locations, such as a bus stop, car wash, day labor pickup sites, agricultural sites, and the like. 2, the type of work one does. 3, speaking Spanish or speaking English with an accent. And 4, apparent race or ethnicity. Seems like a reasonable ruling to me. None of those things should give somebody probable cause to detain somebody for any length of time. Period. Just existing and standing in a particular location should not make me think, oh, that person is violating our immigration policies, any more than standing in another position. Period. All right, Maurice, in the chat, saying President Trump is saving our republic from globalist commie criminals. No, you forgot an extra K, and that's who he's protecting. He's protecting the triple K, folks. Sorry, bruh. You're wrong. And I get the fact that it was a Steve Miller reference because, I called you Maurice. Anyway, the government contends that the injunction will substantially hamper its efforts to enforce immigration laws to the Los Angeles area. Why? Y'all have been seizing everybody under the sun regardless of whether or not they are actually here legally or not. Why do you think that this is going to stop you? I think the government should have to prove that it's doing things reasonably for us to assume that they're doing things reasonably. Kavanaugh apparently doesn't agree. Kavanaugh doesn't need to hear about all the different ways that this administration has absolutely seized people here legally and detained and or deported and or banned them from re-entry into the country for 10 years. Off of claims that they might have done something wrong, but without proof that they did something wrong, because the Supreme Court has also determined and ruled that every person detained has the right to file a writ of habeas corpus because everybody has the right to due process. 9-0 ruling, including Alito and Thomas, for anybody who wants to disagree with me in the chat. To obtain a stay from this court, the moving party must demonstrate a fair prospect that if the district court's decision were affirmed on appeal, that the court would grant seniority in reverse. The moving party also must show the likelihood that it would suffer irreparable harm if a stay were not granted. Those two factors are the most critical, particularly in close cases. Why is this a close case? Administration is acting like a bunch of scumbags as it pertains to immigration. Shouldn't be a close case at all. In my view, Kavanaugh's view, the government has made a sufficient showing to obtain a stay pending appeal. Well, you're an idiot. Did you have your daily beer today, Kavanaugh? To begin with, the significance of the issue to the government's immigration enforcement efforts, this court will likely grant seniority if the Court of Appeals affirmed the district court's injunction. In addition, on 2 alternative grounds, the government has demonstrated a fair prospect of reversal of the district court's injunction. First, under this court's decision in Los Angeles v. Lyons, plaintiffs likely lack Article 3 standing to seek a broad injunction restricting immigration officers from making these investigative stops. Why? Because they haven't done it enough? Do they need to do it a certain amount of times in order for them to get, an injunction? In Lyons, the court held that standing to obtain future injunctive relief does not exist merely because plaintiffs experience past harm and fear its recurrence. What matters is the reality of the threat of repeated injury, not subjective apprehensions. Well, we've already seen, as I've described earlier, that we have a consistent threat that this administration is not going to follow the rules that y'all set forward by requiring everybody in a 9-0 ruling get the ability to, challenge their detainment. They didn't do that with all 28 of those Filipinos that were seized at the cruise ship port, did they? No, they did not. Plaintiff's standing largely tracks the theory that rejected Lyons. Like in Lyons, plaintiffs here allege that they were subjects of an unlawful law enforcement action in the past, namely being stopped for immigration questioning, allegedly without reasonable suspicion of unlawful presence. And like in Lyons, the plaintiffs seek a forward-looking injunction to enjoin law enforcement. But, again, the government has proven that they're not trustworthy as it pertains to who they're detaining. Because they have shown that they don't give a shit about who they're detaining. Not one bit. Plaintiff's standing theory is especially deficient in their case because the immigration officers also use their experience to stop suspected illegal immigrants based on a variety of factors. Did that experience stop them from detaining and deporting and banning 28 people who are cruise ship workers from this country? No. Did it stop them from detaining and deporting a child getting health care who is a citizen of this country because that person's parents may have very well been here in violation of our border policies. I mean, you could at least have a fucking heart and be like, you know what, maybe we'll make an exception for these folks because this kid's a citizen and this kid is getting treatment. So therefore, maybe we let the parents stay while the treatment is getting had. Nope. What about the person who was detained in the San Francisco airport for days, if not a week or more, because, you know, they suspected the person of being here in violation of our border policies? Person had a green card. They've gotten it wrong. So how many times must the federal government get this wrong before the courts say, yeah, you know what, they're fucking up? To stop an individual for brief questioning about immigration status, the government must have reasonable suspicion the individual is illegally present in the United States. And what reasonable suspicion is a lesser requirement than probable cause and considerably short of the preponderance of the evidence standard. Whether an officer has reasonable suspicion depends on the totality of the circumstances. Here, those circumstances include that there is an extremely high number and percentage of illegal immigrants in the Los Angeles area, that those individuals tend to gather in certain locations to seek daily work, that those individuals often work in certain kinds of jobs, blah, 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 that many of these people illegally in the Los Angeles area come from Mexico or Central America, do not speak much English. Okay, but again, what if they're a tourist who's, you know, needing something at Home Depot and they go get something and, oh, sorry, we're detaining you now because you don't speak English and you're at a Home Depot, so fuck you. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. I guarantee you that that's all they're using. They may claim to use other things, but they're not just, they're pretty much just saying, oh, Hispanic, lock them up. That's what they're doing. In short, given this court's precedents, the government has demonstrated a fair prospect of success both in standing and on Fourth Amendment grounds. To conclude otherwise, the court would have to overrule the significantly narrow two separate lines of precedents. Well, you've done that before. You've done that with Roe v. Wade and Planned Parenthood v. Casey, didn't you? Y'all love overturning Supreme Court precedents, and more is coming down the pipe, I'm sure. You don't give a crap about the requirements to overturn rulings. You're just going to overturn rulings because you don't like them. Or you'll keep them in place because you do like them. So in this case, particularly given the millions of individuals illegally in the United States, the myriad significant economic social problems caused by illegal immigration, what is that? What is the myriad and significant economic and social problems? Like, you know, all the Trump agendas that are killing all of the, you know, Iowa farmers, those. The strawberry fields in Tampa Bay, Florida, that are just, you know, have molding fruit on the vine because they can't hire anybody. Is that what you're talking about? Let's scan past Kavanaugh's BS because, you know, he concurs, but we're gonna zoom past that. Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined, dissenting. Early June, government launched immigration enforcement raids across Los Angeles and surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, easy for me to say, parks, and began seizing individuals on site, often before asking a single question. Again, before asking a single question, i.e. not taking the time to determine what all the entirety of the circumstance was, just looking at a person, seeing that they're Hispanic, and saying, yoink, sorry. Federal District Court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment based on the evidence before it. The court held the government was stopping individuals based solely on four factors: their race, if they spoke Spanish or English, with an accent, the type of location where they were found, and the type of job that they appeared to be working for, concluding that stops based on these four factors alone, even when taken together, could not satisfy the Fourth Amendment's requirement of reasonable suspicion. The district court temporarily enjoined the government from continuing its pattern. Of course, the government doesn't give a shit. They'll just do it somewhere else. But, you know, they're continuously challenging the rulings that all the courts, including the Supreme Court, make, because after the Supreme Court ruled 9-0 that they had to give people due process, even non-citizens, like, you know, the Constitution requires, they're still not doing it. Because, again, 28 people detained and deported who were Filipino cruise workers out of Norfolk, Virginia. Those people were not given adequate time to challenge their detainment as required by the Supreme Court ruling. Not one bit. Instead of allowing the district court to consider these troubling allegations in the normal course, the majority of this court decides to take the once extraordinary step of staying the district court's order. That decision is yet another grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work at a low-wage job rather than stand idly by while our constitutional freedoms are lost. I dissent. I do too. Early June, the government launched Operation at Large, deploying roving patrols of armed and masked immigration agents to local car washes, Home Depots, tow yards, bus yards, blah, blah, blah. Over the course of the next month, government made 2,800 immigration-related arrests and detained many more. For instance, on June 9th, immigration agents arrived at a tow yard in Montebello carrying handguns, military-style rifles. Jason Gavita, Latino U.S. citizen, was working on his car in the tow yard that day. Masked agent ordered him to stop right there and began asking him questions. Agents then asked him whether he is an American at least 3 times. Gavita affirmed that he is. Unsatisfied, the agents asked Gavita for the name of the hospital which he was born, and when Gavita could not immediately recall it, the agents racked up a rifle, took Gavita's phone, pushed him against the metal gated fence, put his hands behind his back, and twisted his arm. Agents realized Gavita only after he had offered up his real ID. That ID was never returned to him. Less than 10 miles away in Whittier, immigration agents raided a car wash managed by U.S. citizen Jorge Viramontes. In the 9 days between June 9th and 19th, agents returned 4 times, each instance in the middle of the workday. On one occasion, an agent questioned Viramontes, asking if he was a citizen and requesting that he show his ID. Viramontes replied that he is a dual U.S. citizen and Mexican citizen and supplied his California driver's license. The agent said the ID was insufficient, grabbed his arm, escorted him to a vehicle, and drove him to a warehouse for further questioning. I.e., they are not taking the time to determine whether or not they're a citizen or not before detaining these people. Operation at Large encounters have included even more force and fewer questions. For example, agents pulled up in 4 unmarked cars to a bus stop in Pasadena. Doors opened. Men in masks with guns started running at 3 Latino men who were having their morning coffee, waiting to be picked up for work. In Glendale, nearly a dozen masked agents with guns jumped out of cars at Home Depot, began chasing and tackling Latino day laborers without identifying themselves as ICE or police, asking questions or saying anything else. In downtown Los Angeles, agents jumped out of a van, rushed up to a tamale vendor, surrounded him and handed him violently, all without asking any questions. So they're not taking the time to ask the questions required to determine whether or not they're here legally, but yet Kavanaugh is going to be a fucking idiot, and the rest of the conservative activists on this court are also going to be idiots and uphold and not stop this administration from acting in their bully, racist, bigoted ways. One Latino U.S. citizen feels like he needs to carry his passport for protection in case federal agents stop him again. Another Latino U.S. citizen similarly worries that as visibly Latino man, he could be detained if he does not carry his passport, but decided against doing so because he believes as an American, he should not have to live like that in his own country. He is correct. Gavidia, Viramontes, 300 individuals stopped during Operation at Large, and 4 associations filed this putative class action against Secretary Noem and other senior federal immigration enforcement officials. As relevant, the plaintiffs allege the government has violated the 4th Amendment by adopting a policy, pattern, or practice by stopping individuals without reasonable suspicion, and I think they've proven their case, but of course, Kavanaugh doesn't seem to think so, because Kavanaugh is a fucking idiot, and probably drunk at that, in my opinion. In opposition to the motion for a TRO, the government submitted 2 declarations generally describing its operations. One stated the government officers are trained to consider the totality of the circumstances, which they're not doing, and that certain types of businesses, including car washes, have been selected for encounters because of past experience. They've demonstrated that illegal aliens utilize and seek work at these locations. Oh no, which means everybody's there must be terrible, right? District Court granted the TRO. The court found that there was ample evidence that seizures occurred based solely on the 4 enumerated factors, either alone or a combination. Indeed, the government submitted no evidence suggesting that seizures to date were based on anything other than those 4 factors. The court further found a plethora of statements suggesting approval or authorization of the government's pattern of relying solely on the 4 factors, yada, yada, yada. Accordingly, the court entered a TRO providing a relative in part. As required by the 4th Amendment of the United States Constitution, defendants shall be enjoined from conducting detentive stops in this district unless the agent or officer has reasonable suspicion that the person being stopped is within the United States in violation of U.S. immigration law. In connection with paragraph A, defendants may not rely solely on the factors below, alone or in combination, to form reasonable suspicion for a detentive stop, except as permitted by law: apparent race or ethnicity, speaking Spanish or English with an accent, presence with a particular location, or the type of work that they're doing. The government appealed to the Ninth Circuit and moved for a stay. In doing so, it submitted an additional declaration reiterating the officers are trained that under the Fourth Amendment, blah, blah, blah. But of course, they didn't do that because they're clearly not doing that because they're clearly a bunch of racist bigots who just want to detain Hispanic people and deport them from this country. Or maybe even lock them up and put them in internment camps and then put them to work to build the wall. Because that was my proposal back in 2018. In 2018, I had suggested that, step one would be build internment camps. Step two, make the people, do day labor to build the wall, yada, yada, yada. We already have the internment camp. So I was dead on balls accurate. I think the only person who maybe have been more right about Donald Trump than me about what he will do as a president was Hal Sparks. And I tagged him in that post and let him know, and he liked it. So anyway, Fourth Amendment imposes limits on search and seizure powers to prevent arbitrary and oppressive interference by government officials with privacy and personal security of individuals, not just citizens, individuals, but they're detaining citizens. They're taking citizens to warehouses. They are not taking care to make sure that these people are who they say they are and who they believe that they are to be, because they're racists. This is a racist administration enacting racist and bigoted policies, and to continue to support them is deplorable. Plant Man Podcast says, cry harder, libs. Why aren't you standing up for the Constitution? Are you a conservative? Y'all used to claim to love the Constitution. Y'all don't give a rat's ass about the Constitution. Constitution is toilet paper for y'all. Charmin. It's not even Charmin because it's not two-ply and doesn't have any cushy ripples or anything else to make the wiping on your hindquarters feel any better, but y'all don't care about that because as long as Hispanic people and other people who are, not white are being detained, you are laughing and clapping it up like a bunch of idiot morons. Simple as that. Bald Thanos, I agree with you. I loved Silverhawks as a kid. Let's kind of scroll down, see if there's anything more to be said. Government and the concurrence also attacked the named plaintiff standing to seek conjunctive relief. Lyons does not bear the weight of the government, and the concurrence placed on it provides no valid basis to justify the majority's intervention. Our standing requirement ensures that each plaintiff has a personal stake in the outcome. And Lyons, the plaintiff, had sought an injunction against the city of Los Angeles after a police officer applied a chokehold to him in violation of the department's policy and allegedly the Fourth Amendment. The plaintiff lacked the standing, the court said, because he failed to establish a likelihood of recurrent injury. The court cited lack of evidence in this instance that the city ordered authorized police officers to act in such a manner, emphasized that the district court did not otherwise make a finding, blah, blah, blah. And as we've already stated, there has already been plenty of evidence to show that the government is showing a pattern of operation. Anyway. Keep on scrolling. Finally, government challenges the scope of ordered relief, arguing that the district-wide injunction violates the court's recent holding in Trump v. Casa, but that is not a significant basis, yada, yada, yada. Applicant must not only show a likelihood of success in the merits, but must also demonstrate that the implementation of the judgment pending appeal will lead to irreparable harm. In deciding whether to grant a stay, this court, moreover, must balance the equities and explore the relative harms to applicant and respondent, as well as the interests of the public at large. In this case, the court yet again grants emergency relief to the government when irreparable harm is sorely lacking. The government's sole argument on this score is that the TRO chills its enforcement efforts. Well, maybe it should be chilled because, you're violating the law in doing so. Bunch of dumbasses. Let's scroll down even more. Is there anything else in here that is... Nope, that's about it. Okay. So there we go. So apparently in the chat we were told to cry harder because, we're libs and, we're trying to cry harder, right? What we're only doing is, standing up for the Constitution and the requirements that the Constitution set forth as limits on the federal power. Y'all used to hate small government. Y'all used to love small government, except, you wanted a government so small that it could fit inside a woman's vagina. That being said, y'all would, had Biden been taking, activating the military and sending it to cities and been doing all of these actions in a way that was violation of the Constitution, y'all would speak up, y'all would have yelled, screamed, moaned, complained, whined, bitched, moaned, whatever, etc. Y'all would have done all that stuff to complain about all of the horrible things that, Biden is doing. But, had Biden done it, whatever, but Trump does it, and it's okay, as my song says. Had Biden done it, MAGA would flip. Had Biden done it, poll numbers would slip. Had Biden done it, Fox News would say oy vey, but Trump did it, so it must be okay.